Hello Year 11s and welcome to this video on the methods used to resolve civil disputes. There are 4 things that you need to do while you watch this video. The first thing is to take the very best Cornell notes that you can. The second thing is to use the pause and rewind functions. Use the pause function if you need to stop this video to take notes. Use the rewind function if you need to go over any information contained in this video. The third thing that you need to do is have your summary books open in front of you. As we go through this video, I will give you some guidance as to what you should include in your summary books. And the fourth thing you need to do is have your vocabulary sheets open in front of you so that you can write into your vocabulary sheets the definitions of key terms and of any other words the meaning of which you're unfamiliar with. Once you've finished watching this video, please read the pages from the textbook referred to on this slide. And if you find any additional information from that reading that you think is useful, then supplement your Cornell notes with that additional information. Well, let's get started then. On this slide, I've set out the learning intention for this video. As a result of watching and taking notes on this video, you should be able to describe the methods used to resolve a civil dispute, such as mediation, conciliation, and arbitration. Make sure that you write this learning intention down in your Cornell notes. Mediation, conciliation, and arbitration are all methods that can be used to resolve civil disputes. They're not used to deal with crimes. As such, mediation, conciliation, and arbitration provide an alternative way for parties to resolve a civil dispute instead of having their dispute resolved by a court at a trial or court hearing. As we'll see, like a judge in a court, the mediator, conciliator, or arbitrator is an independent and impartial third party. However, the advantage of using these 3 dispute resolution methods rather than having a civil dispute resolved by a court is that mediation, conciliation, and arbitration are generally less expensive and less time-consuming than a court hearing. This is because mediation, conciliation, and arbitration typically involve less formal proceedings than a court hearing. This means that the parties are able to represent themselves, which means that they can avoid paying the costs of a lawyer to represent them. As we'll see, sometimes the courts will order that the parties to a civil dispute must try to resolve their dispute using one of these dispute resolution methods before the court will set the dispute down for a trial. The reason for this is that it will save the time and resources of the courts if the parties are able to resolve their dispute without a court hearing, that is, without a trial. In fact, any parties with a civil dispute can try to resolve the dispute by mediation, conciliation, or arbitration without a court being involved in this way. Providing that both parties agree, then they can appoint a mediator, conciliator, or arbitrator to help them to resolve their dispute.
The first dispute resolution method that we're looking at is mediation. Mediation is a method of dispute resolution for civil disputes where an independent third party, called the mediator, gives each party a reasonable opportunity to explain their side of the dispute, but does not decide the dispute for them. Look down the left-hand side of your vocabulary sheets, find the term mediation and write this definition in there. There are 5 points to note about mediation. First, the role of the mediator is to make sure that both parties are given a reasonable opportunity to explain their side of the dispute to the other party. Second, unlike in a conciliation, the mediator does not make suggestions to assist the parties to resolve their dispute. Third, most importantly, the mediator does not decide the dispute for the parties. Instead, it is entirely up to the parties to try to agree a resolution to their dispute. Fourth, the parties are able to bring support people or representatives to the mediation. Sometimes this might include a lawyer. And fifth, any agreement between the parties that is made in mediation is not binding. In other words, a party can agree a resolution of the dispute in a mediation, but can subsequently refuse to comply with that agreement. That's why, when the parties agree a resolution to their dispute in mediation, they will generally sign a settlement deed, that is a legally binding agreement, which sets out the terms of their agreement to resolve the dispute. These terms might, for example, be that one party will pay the other party a certain amount of money to resolve the dispute. A settlement deed, as I've said, is a legally binding agreement. So if one party refuses to comply with that agreement, then the other party can sue them for breach of contract and obtain an order from a court that requires the infringing party to comply with the agreement. For example, if a party agrees to resolve their dispute with the other party by paying the other party a sum of money, and if that agreement is set out in a settlement deed, then if the party refuses to pay the other party that sum of money, then the party who is owed the money can get an order from a court requiring the party to pay them that amount of money. All of the Victorian courts, that is the Magistrates Court, the County Court and the Supreme Court, can use mediation to resolve civil disputes in the sense that they can direct the parties to try to resolve their dispute by mediation before the dispute is heard by the court. In such a case, the mediator will be a person who is either chosen by the court or who is agreed by the parties, assuming that the parties can agree on the mediator.
But even without going to the courts to resolve their dispute,
the parties themselves can try to resolve their dispute by mediation if they both agree to use mediation. The Dispute Settlement Centre of Victoria is one of a number of agencies that provides mediation services to parties who wish to try to resolve their dispute by mediation. The second dispute resolution method that we're looking at is conciliation. Conciliation is a method of dispute resolution for civil disputes where an independent third party, called the conciliator, gives each party a reasonable opportunity to explain their side of the dispute and makes suggestions to help the parties agree a resolution of their dispute, but does not decide the dispute for them. Look down the left-hand side of your vocabulary sheets, find the term conciliation and write this definition in there. There are 5 points to note about conciliation. First, similarly with a mediation, the role of the conciliator is to make sure that both parties are given a reasonable opportunity to explain their side of the dispute to the other party. Second, unlike in a mediation, the conciliator makes suggestions to assist the parties to resolve their dispute. Third, most importantly, and also like a mediation, the conciliator does not decide the dispute for the parties. Instead, it's entirely up to the parties to try to agree a resolution to their dispute. Fourth, also like a mediation, the parties may bring support people or representatives to the conciliation, sometimes including a lawyer. And fifth, again like a mediation, any agreement that the parties reach in a conciliation to resolve their dispute is not binding on them. In other words, a party can agree a resolution of the dispute in a conciliation, but later refuse to comply with that agreement. That's why, when the parties agree a resolution to their dispute in a conciliation, they will generally sign a settlement deed that sets out the terms of their agreement to resolve their dispute. A settlement deed is a legally binding agreement, so if one of the parties refuses to comply with that agreement, then the other party can sue them for breach of contract and obtain an order from a court that requires the infringing party to comply with that agreement. All of the Victorian courts, that is the Magistrates Court, the County Court and the Supreme Court, can use conciliation to resolve civil disputes in the sense that they can direct the parties to try to resolve their dispute by conciliation before the dispute is heard by the court. This may be appropriate where the parties need a more directive approach than mediation can provide. In other words, where the parties need someone to provide them with suggestions about how they can resolve their dispute. When the county court or the Supreme Court directs the parties to try to resolve their dispute by conciliation, then the conciliator will be a person who is either chosen by the court or who is agreed to by the parties, assuming that the parties can agree who the conciliator should be. In the Magistrates' Court, a pre-hearing conference is held for most civil matters. This is a hearing before a registrar of the Magistrates' Court, that is a court official, to try to resolve the dispute or at least settle some of the issues that are in dispute between the parties. In this way, the registrar acts as a conciliator by suggesting how the dispute can be resolved or how some issues in dispute between the parties can be resolved.
But even without going to the courts to resolve their dispute,
the parties themselves can try to resolve their dispute by conciliation if they both agree to use conciliation. The Dispute Settlement Centre of Victoria is one of a number of agencies that provides conciliation services to parties who want to try to resolve their dispute by conciliation.
on this slide I've set out some circumstances in which mediation or conciliation would be an appropriate method to resolve a civil dispute.
Broadly speaking, mediation or conciliation will be appropriate dispute resolution methods in 5 types of circumstances. The first is where it's important for the parties to preserve a continuing relationship between them. For example, as where the dispute is between neighbours or between business partners. The advantage of mediation or conciliation is that the parties can resolve their dispute by agreement. For there to be an agreement, both parties will generally need to compromise. Accordingly, there will be no clear-cut winner and no clear-cut loser.
On the other hand, if the parties take their dispute to a court hearing,
then this is a very adversarial process where both parties are trying to win. This can be very damaging to relationships, and in the end, of course, the court will decide the dispute, and there will typically be a clear-cut winner and a clear-cut loser. The second type of circumstances where mediation or conciliation is an appropriate dispute resolution method is where both parties are willing to compromise. This is necessary because in a mediation or conciliation, the mediator or conciliator does not decide the dispute for the parties. Instead, it's entirely up to the parties to agree a resolution to their dispute. The parties are more likely to compromise and therefore to reach an agreement if they trust each other, if there's not an imbalance of power between them, and if there are no overwhelming emotions, for example, as is the case in a family law dispute. Thirdly, mediation or conciliation will be appropriate where the parties want to resolve their dispute at an early stage to avoid legal costs.
As I've said before, mediation and conciliation are typically less expensive and less time-consuming for parties than where parties have their dispute resolved by a court hearing. This is because the procedures that are used in mediation and conciliation are less formal than in a court. For instance, the technical and complex rules of evidence and procedure that apply in court hearings do not apply in a mediation or conciliation. As a result, the parties can represent themselves and do not need to pay a lawyer to represent them. This will save the parties a lot of money because they don't have to pay legal fees. Mediation and conciliation are also quicker ways to resolve disputes than going through the courts because, unlike with the courts, there is no backlog, and so the parties don't have to wait to have a mediation or conciliation.
Fourthly, mediation or conciliation will be appropriate where the parties want to resolve their dispute in private. Unlike at a court hearing, there is no requirement for mediation or conciliation to be held in public, and in fact most mediations and conciliations are not held in public but in private. And finally, mediation or conciliation will be appropriate to resolve a dispute where the issue in dispute is clear. For example, where the defendant has already admitted liability to the plaintiff, and so the only question is the amount of compensation which the defendant should be required to pay to the plaintiff. This is a very clear question which is capable of being decided by agreement by the parties.
With this background, we can now look at the strengths and weaknesses of mediation and conciliation as dispute resolution methods. I've set out these strengths and weaknesses in the table on this slide. Please include a copy of this table in your summary books, and as you listen to the discussion which follows, make such additional notes on the table as will help you better explain it. The main strength of mediation and conciliation is that the dispute is resolved by the parties. They're not forced to reach an agreement, but will only come to an agreement if they are both happy to do so. To reach an agreement, both parties will probably need to give up something. That is, they'll need to compromise. This means that, unlike in court proceedings, there is no clear-cut winner and no clear-cut loser. Instead, if the parties are able to reach an agreement, it will be because they're able to agree a solution that suits each of them. Put another way, they will both have bought into the agreement, and so should both be willing to comply with that agreement. While the fact that the dispute is resolved through agreement in a mediation or conciliation is the main strength of mediation and conciliation, it is also its most significant weakness. This is because there's no certainty that the parties will be able to resolve their dispute by reaching an agreement. If they can't agree, then the parties will have wasted time and money in mediation or conciliation, and they'll still need to have a court resolve their dispute at a trial or hearing. In addition, any agreement reached at a mediation or conciliation is not binding unless the parties sign a settlement deed. A settlement deed is a contract that sets out the way in which the parties have agreed to resolve their dispute. For example, if Jeremy sold Jacinta a car for $10,000 and there was a dispute about whether Jeremy had promised Jacinta that the car was a new car, then Jeremy and Jacinta might agree to resolve their dispute by Jacinta still buying the car but only paying $8,000 for it. Provided Jeremy and Jacinta have signed a settlement deed, then, if Jacinta failed to pay the $8,000, Jeremy could sue Jacinta in court for breaching their settlement deed, and the court would order Jacinta to pay the $8,000 to Jeremy. It's very sensible and usual practice for parties who reach an agreement in a mediation or conciliation to sign a settlement deed that sets out the way in which they've agreed to resolve their dispute. Another strength of mediation and conciliation is that it can result in a dispute being more quickly resolved than if the dispute was taken to court.
This is because there's no backlog of mediation and conciliation cases, unlike court cases.
The procedures used in mediation and conciliation are also less formal than in the courts. In particular, the technical and complex rules of evidence and procedure that apply to court cases don't apply in mediation and conciliation. In addition, because mediation and conciliation don't occur in a courtroom, the parties are likely to feel less intimidated at a mediation or conciliation. This means that the parties are more likely to be prepared to represent themselves because they don't need to understand the law or to understand the rules that apply in court. This in turn means that it is cheaper to resolve disputes using mediation or conciliation rather than at a court hearing where the parties will generally need to be represented by lawyers. If the parties represent themselves in a mediation or conciliation, then there's no need to pay the costs of lawyers. However, the less formal procedures of mediation and conciliation do mean that sometimes one party might try to dominate the other party, that is, bully them into an agreement, and that one party might decide to be uncooperative, which will mean that it is less likely that the parties will reach an agreement. Yet another strength of mediation and conciliation is that they are held in private and the outcome is confidential. This can be beneficial because parties are more likely to be willing to compromise if their negotiations are not held in public, where any sign of compromise might be interpreted as a sign of weakness. And finally, in a conciliation, but not in a mediation, the conciliator is generally an expert in the subject matter of the dispute. This is important because it means that the conciliator is in a much better position to make suggestions to help the parties to resolve their dispute.
The third dispute resolution method that we're looking at is arbitration. Arbitration is a method of dispute resolution for civil disputes where an independent third party, called the arbitrator, listens to both sides of the dispute and makes a decision that is binding on the parties. Look down the left-hand side of your vocabulary sheets, find the term arbitration and write this definition in there.
There are 4 points to note about arbitration.
First, the arbitrator must ensure that both parties are given a reasonable opportunity to present their case. Second, the arbitrator is not bound by the rules of evidence and procedure that apply in the courts. Instead, the parties can agree their own rules of procedure to apply to the arbitration, and so arbitration tends to be less formal
than a court hearing.
Third, unlike mediation and conciliation, the dispute is resolved by a decision made by the arbitrator. That is, the dispute is not resolved by agreement between the parties. This decision of the arbitrator is called an arbitral award.
And fourth, the arbitrator's decision is binding on the parties. This slide sets out how the courts can use arbitration to resolve civil disputes.
Where the civil dispute is for less than $10,000 and is brought to the magistrates' court, that dispute must be resolved by arbitration. In such a case, the magistrate is the arbitrator. The difference is that, unlike a hearing in the magistrates' court,
the rules of evidence and procedure do not apply when the magistrate is acting as an arbitrator.
The county court and the Supreme Court, as well as the magistrates' court for civil disputes in excess of $10,000, can use arbitration to resolve civil disputes in the sense that they can refer the dispute to arbitration. That is, they can direct that the dispute is to be resolved by arbitration. However, because the arbitrator's decision is binding on the parties' consent is required for this referral.
If this weren't the case, then the parties would be deprived of their right to have their case determined by the court.
In such a case, the arbitrator will be either chosen by the court or agreed by the parties, assuming that the parties can agree on the arbitrator.
Finally, without even going to court, the parties themselves can agree to have their dispute resolved by arbitration.
The Victorian Bar Dispute Resolution Scheme is one of a number of bodies that provides arbitration services to parties who want to have their civil disputes resolved by arbitration.
On this slide, I've set out some circumstances in which arbitration would be an appropriate method to resolve a civil dispute.
Broadly speaking, there are 3 types of circumstances in which arbitration will be an appropriate dispute resolution method. First, arbitration will be appropriate where the parties want the decision resolving their dispute to be binding. Remember that, unlike in a mediation or conciliation, in an arbitration, the dispute is resolved by a decision made by the arbitrator, not by agreement between the parties. And furthermore, the arbitrator's decision is binding on the parties. That is, the parties must comply with that decision. Second, arbitration will be appropriate where the parties want their dispute to be resolved in accordance with less formal rules of evidence and procedure than apply in court. Remember that the arbitrator is not bound by the rules of evidence and procedure that apply in the courts, and instead the parties can agree their own rules of procedure that are to apply to their arbitration. Third, arbitration will be appropriate where the parties want to resolve their dispute in private. Unlike the case with the courts, in the case of arbitration, there's no requirement for the arbitration to be held in public, and certainly most arbitrations are held in private.
With this background, we can now look at the strengths and weaknesses of arbitration as a dispute resolution method. I've set out these strengths and weaknesses in the table on this slide. Please include a copy of this table in your summary books, and as you listen to the discussion which follows, make such additional notes on the table as will help you better explain it. The main strength of arbitration is that the arbitrator's decision, which is also known as an arbitral award, is binding on the parties. That is, the parties must comply with that decision. If one party refuses to comply with the arbitrator's decision, then the other party can apply to a court for an order that requires the party to comply. So, unlike mediation and conciliation, where the dispute will only be resolved if the parties are able to reach an agreement, in an arbitration, the dispute is resolved by a third party, that is, the arbitrator deciding the dispute for the parties, and the parties must comply with the arbitrator's decision. However, this does mean that the parties don't control the outcome. The arbitrator simply tells them what the decision is, and it's too bad if one party doesn't like the decision. Another strength of arbitration is that it can result in a dispute being more quickly resolved than if the dispute was taken to court. This is because there's no backlog of arbitration cases, unlike court cases. On the other hand, if the dispute is large and complex, then the arbitration of that dispute can take a long time, just like a court case. It can also be quite expensive, as the parties are more likely to want to be represented by lawyers to ensure that their best case is put forward, because the arbitrator's decision will be binding on them. Nonetheless, arbitration is less formal than court proceedings. The technical and complex rules of evidence and procedure that apply to court cases don't apply in arbitrations. Instead, the parties can agree the procedures or rules that are to apply in their arbitration.
This means that a party might be willing to represent themselves and so save on the costs of having a lawyer represent them. However, even where a party is represented by a lawyer, as will often be the case in an arbitration, the cost of resolving the dispute by arbitration will often be less than the cost of having the dispute resolved through the courts. This is because the less formal procedures that the parties can agree for their arbitration mean that an arbitration is likely to be more quickly completed than a court case. Because lawyers typically charge by the hour, even if lawyers are involved in the arbitration, then the parties' legal costs are likely to be lower than for a court case.
Yet another strength of arbitration is that it's held in private and the outcome is confidential. Accordingly, parties will prefer this dispute resolution method over court proceedings, which are generally open to the public, if the parties want to avoid the dispute being publicised. And finally, in an arbitration, the arbitrator is an expert in the subject matter of the dispute. This is important because it means that the arbitrator will be well qualified to decide the dispute for the parties. Well, that brings us to the end of this video. As a result of watching and taking notes on this video, you should now be able to describe the methods used to resolve a civil dispute, such as mediation, conciliation, and arbitration. Remember to read the pages from the textbook referred to on the first slide. And if you find any additional information from that reading that you think is useful, then supplement your Cornell notes with that additional information. Thank you for your attention.